Okay, welcome to the regularly scheduled meeting of the Montezuma County Planning and Zoning Commission. It's being held, it's being held at the Commissioners Meeting Room in Montezuma County Administrative Offices, 109 West Main, Room 250, Cortez, Colorado. We're going to open with the Pledge of Allegiance and a moment of silence. I pledge allegiance to the flag, United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, I'll speak a little closer. I will do that. Okay, Don, can we have roll call, please?
Commissioner Hernandez?
Here.
Commissioner Neergaard?
Here.
Commissioner Lynch?
Here.
Commissioner Armstrong?
Here.
Commissioner Doyle?
Here.
Okay, also present, Don Haley from the Planning County Department, and absent is Commissioner Saunders. Please silence your cell phones during the meeting. Important calls can be taken outside in the foyer there. Okay, has the Planning and Zoning Commission reviewed the March minutes?
Yes.
Okay.
Yes.
Okay. Do we have any additions or corrections to those minutes?
Yeah, I do. I made comments in the commissioner's comments to include the potential for revenue relative to it was a camping site from tax and expenditures. I'd like that included. Here we go. The need for revenue in the county were not included as part of the commissioner discussions. And I would think that was very important from tax revenue, be it from employees, as well as expenditures from people that would be using the facility.
Okay.
Were those, question,
Yes.
were those comments by commissioners that were left out or by public comment that was left out?
They were made during the meeting, but they were not included in the minutes.
Yeah, our meeting. Yeah.
Yeah.
And I do remember those comments.
I was told they were put in the newspaper even.
I'll see they're covered. They're memorialized.
Already done.
I didn't
Okay,
read it, but that's what I was told.
then I'll entertain a motion for the minutes to be approved as amended.
I'll make a motion to approve the planning and zoning minutes for March 13th as amended.
Do we have a second?
I'll second.
Okay, we call for vote, please.
Commissioner Hernandez?
Aye.
Commissioner Neergaard?
Aye.
Commissioner Lynch?
Aye.
Commissioner Armstrong?
Aye.
Commissioner Doyle?
Aye.
Okay, as amended. Okay, the Montezuma County Planning Commission welcomes you to this meeting. This board is comprised of members who are tasked to make recommendations to the Board of County Commissioners. We are not the decision makers. We encourage public comment after each permit. Persons speaking during public comment will be limited to 3 minutes, or depending on the number of people wishing to speak, it may be reduced at the discretion of this board. To allow all members of the public the opportunity to address their thoughts and concerns when addressing the commission, please come to the podium, State your name and address for the record prior to providing your comments. Comments to individual applicants are not permitted, and participants may not yield their time to others. I shall be voting tonight. Can we have roll call done?
Commissioner Hernandez,
Here.
Commissioner Nergard,
Here.
Commissioner Lynch,
Here.
Commissioner Armstrong,
Here.
Commissioner Doyle.
Here.
Okay, number one with the application of EchoLoBue, we understand it has been postponed,
Correct. It is-
and we will entertain a motion to postpone it to a time to be determined later, because we do not have,
We don't have a time,
A time.
but it was noticed in the newspaper, so
Okay.
we'll just continue it to a TBD date.
okay, so
And
we'll
it'll have to be renoticed and packets sent out.
all right, we'll entertain a motion for someone to,
I'll make a motion that we continue
okay,
this to a later date to be determined.
second, anyone?
I'll second.
Okay, we have a motion and a second. No discussion. We'll call for the vote then.
Commissioner Hernandez,
Aye?
Commissioner Nergard,
Aye.
Commissioner Lynch,
Aye.
Commissioner Armstrong,
Aye.
Commissioner Doyle.
Aye.
Okay, roll call, please. Again.
Commissioner Hernandez,
Here.
Commissioner Nergard,
Here.
Commissioner Lynch,
Here.
Commissioner Armstrong,
Here.
Commissioner Doyle.
Here.
Okay, number two, notice is hereby given that the Montezuma County Planning and Zoning will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed four-lot moderate subdivision and AR 3-9 and AR 10-34 rezoning application submitted by Troy Jaskowski on property located at 30261 Road H, Cortez, Colorado, consisting of 38.80 acres, more or less, located south of Highway 160, east of Road 27, situated in Section 34, Township 36 North, Range 15 West of the New Mexico Prime Meridian. This is a public hearing. Was the public notice published?
Yes,
Were evidence of letters to the adjoining neighbors and mineral owners submitted?
yes,
Was a sign posted?
yes, it was.
Okay, we have the applicants here.
They
Great.
are.
Can we have planning department findings, please?
Yes, so the applicants are proposing to create a four-lot moderate subdivision consisting of a 20-acre parcel on the west, a 13-acre parcel, and two 3.5-acre parcels. The 3.5-acre parcels will be for future homes with no current plans to build or sell at this time. The proposed 13-acre parcel will be for ag, and the proposed 20-acre parcel currently has a home residence, an RV site as a second residence, along with the 12.5-acre commercial general plan unit development known as Bright Star Campground. Surrounding properties consist of ag and residential uses with state land and other subdivisions, east and west. Agencies were notified March 12th. Let's see. Access is off of Red Road H at the end of the Green Road H. Empire Electric provides power. There is no natural gas. Rural water is through Montezuma Water Company. There's a newly extended 4-inch water line there on the north side of H that has water available for at least 3 additional residences. Septic would be used on the property. No irrigation water. Fire mitigation, Wildfire Adaptive recommends a waiver. And the weed control recommends a waiver on the property as well. It's not located in a floodplain area. The applicants have covenants on the existing Bright Star PUD, and they will need to create covenants if this subdivision's approved.
Okay, thank you. You have anything to add to that? Pretty well nailed it, okay. Okay, commissioners, we have discussion. I know I have some questions myself. The big one, the road, the 13-acre lot, where's the access coming from?
East boundary line.
Eastbound, so it'll be an easement then across the 3.5, okay?
What's the agricultural use at 13 acres?
It'll be reserved as a buffer for the campground.
Could you turn your microphone on?
Please, yeah.
It'll be used as a buffer for the campground.
So the 13 acres are going to be an additional camp?
No.
Okay.
Nope.
That's good, the ag.
Open ag. Yep.
Okay, okay. Across from the
We have
campground.
lovely views from right there. So we want to keep that open.
Okay. How long has that campground been there?
Since 2012,
Okay, that's before me, that's why I haven't
when
seen
it
it.
was Camp Krista. It was a children's Bible camp.
Okay.
Yep, first.
Okay. Okay, anything else, gentlemen?
Yes. So I don't have any concerns about the current applications, but this particular property has come before the Planning and Zoning Board previously while I was on the board. And then subsequently it went to the Board of County Commissioners and was approved. Whenever a permit comes before the board, I believe it's correct to make sure that there is nothing on the property that is out of compliance with the land use code, whether it's regarding the permit that we're looking at or something that is revealed through the permitting process. If we find something that is not in compliance with the land use code, then something would need to be done to mitigate that. And that's my belief anyway. And it was stated by Mr. Haley that this has a commercial, I believe it was called a commercial envelope in the previous application that went before the BOCC, and that applies to a permit that was 12 and a half out of the 20-acre parcel, not the entire 20-acre parcel. And nowhere in the land use code do we have any language saying that you can do a commercial envelope, nor do I believe, there's no language in the land use code, I'm assuming, and I believe it's correct, that any permits must apply to the entire parcel, not to a fraction of a parcel. And because when you do that, it sets up the property for all kinds of things to happen. You could have 3 or 4 different PUDs on the same parcel, and each one doing something different. And so that's why I believe that way. This particular application, I have no concerns over. I have concerns over the applications that have already been approved. In my personal opinion, I don't believe those applications currently comply with the land use code. Obviously, the Board of County Commissioners adopted them, approved them, so I'm in kind of a tough spot here. Based on my belief and understanding of the land use code, I can't vote yes on this permit application because of what I believe exists on the properties. So I hope you understand what I'm explaining, but that's kind of my position.
Don?
So
Shed some light on
the
that?
campground does have a permitted PUD envelope on the 40 acres. It would not extend over to the 13-acre parcel, so that would not need to be amended. A PUD and a high-impact permit can both cover more than one property or a fraction of a property. They are not a full total. That's why there's a legal description done. It's surveyed and it's platted on the plat as the permitted area.
Okay. But the zoning is AR 35?
Correct.
With a PUD?
PUD, yeah, PUD does not change the
It's
zoning.
Right,
It's an overlay on the property.
okay. So then the campground itself is perfectly legal?
Correct.
Okay.
I don't know if the commercial envelope nomenclature is 100% legal, but it's the permitted area for the PUD campground.
But you said that there's a plat that designates the 20 acres, if you will.
It designates
That's
the-
where the PUD is.
The 12.5 acres is surveyed with a legal description.
Okay, 12 and a half acres? As opposed to this, well, the 20, I guess if he cuts a line across. it.
Trusting Jane's notes, I haven't.
Yeah. Wish I'd have seen the plat.
Yeah, you can just, if you just continue that line over, that's the commercial envelope to the north.
The north, okay, so that's the 12
Yep,
acres then,
it
okay.
encompasses the Hogan and then
Okay.
everything to the north.
Okay, anything else? Okay, we're going to open this up for public comment. Anyone wishing to speak for or against this, please come to the podium. State your name and address, if you could turn it on too. Thank you.
Rachel Comiskey, 13267 Road 22, Cortez. And I'm not in opposition of this at all. I believe that people who should be able to use their property as long as it meets the land use code. My only request is that we have a subdivision just to the east of them, and we just put $100,000 into the road. And so we're just requesting that they would put provisions in their subdivision for maintaining the road as well. They, upon their request and the neighbors, put that into our subdivision, and we would just like help with maintaining that road. And that's my only request.
Okay, great, thank you.
Thank you.
And we totally agree with that. That's totally fair.
We'll get to that. Anyone else? Okay, we're going to close the public comment. Now, we can answer that question. I'm sure she was talking about Road H?
Yeah.
Yeah, okay. Which is a green road, is it a red road?
Red.
It's a red road, so it's private,
This is the one that we
the subdivision over
looked
there,
at last
right?
time, so, and that was that big conversation about that road and improving it and keeping it maintained, so. Yes, it's.
Okay. So we said we can do that, right? We can make sure that there's something in your CCNRs.
Yeah, I believe that was the agreement.
You speak a little louder.
I believe that was the agreement for the subdivision project that they have going on. That
Okay.
each resident will need to contribute a portion when needed to maintain the road. Yes. In the future.
Okay.
Yeah.
And the 3.5 acres are going to be sold?
We haven't decided yet.
Okay.
Yeah,
Okay.
we just want to get this done, and then we may build one, sell one. We haven't made that decision
Okay.
yet.
Okay, if we have, bring it back to the commissioners, we'll entertain a motion.
I'll make a motion to commissioners to recommend or to approve a proposed four-lot moderate subdivision in AR 339 and AR 10 through 34 rezoning application submitted by Troy Jaskowski, based on the following. The proposed use is in conformity with the code. The proposed use shall not generate any significant adverse impacts on other properties in the area. The public utilities and services are available, be made available to support uses consistent with the proposed zone. We want to address the road as a condition.
Through condition.
That when
Okay.
they, do their CC and Rs, that they put that in there.
Okay, and then also if those properties are for sale, that the new owners be made aware of the land use code. And that'll be up to you. Okay, do we have a second?
I'll second.
We have a motion and a second. No further discussion. We'll call for the vote.
Commissioner Hernandez,
Aye.
Commissioner Niergaard,
Aye.
Commissioner Lynch,
Nay.
Commissioner Armstrong,
Aye.
Commissioner Doyle.
Aye.
Okay, the motion carried. It was 4-1. Congratulations, thank you.
Did you happen to bring your sign? Sign? Perfect, thank you.
This guy goes here, this guy goes here. Okay, we have roll call done.
Commissioner Hernandez,
Here.
Commissioner Niergaard,
Here.
Commissioner Lynch,
Here.
Commissioner Armstrong,
Here.
Commissioner Doyle.
Here.
Okay, number 3, notice is hereby given that the Montezuma County Planning and Zoning will hold a public hearing for review and determination of the proposed 10-acre single-lot development and AR 10-34 rezoning application submitted by Douglas Family Trust, agent Lori Tunland, on property located at 10900 Road 20, Cortez, Colorado, consisting of 160 acres more or less, located east of Road 20, south of Road M, situated in Section 24, Township 36 North, Range 17 West of the New Mexico Prime Meridian. This is a public hearing. Was the public notice published?
Yes, it was.
Was evidence of letters to the adjoining neighbors and mineral owners submitted?
Yes.
Was a sign posted?
Yes, it was.
Okay, if we can have the applicant come up. Take a drink. Thank you. Okay, can we have the department findings, please?
Just one second. The applicant, they're proposing to create a 10-acre single-lot development in order to construct a holding and training facility for wild horses. Surrounding properties consist of agricultural properties with residences, along with Canyon of the Ancients lands and the BLM lands. Agencies were notified March 12th. Access is off of Road 20. Any new driveway access would need a driveway permit from Road and Bridge. Empire Electric services the area. Montezuma Water Company has a 4-inch line on the east side of Road 20. Currently provides water to the above-mentioned property and has water available for one additional residence service. Irrigation water, there is no water shares. And wildfire adaptive, they recommend a mitigation plan due in part to the moderate wildfire risk, and the majority is covered with pinyon juniper fuels. The property also borders the Canyon of the Ancients National Monument, which is a dense forest. County management, weed management recommends a waiver. No weed issues on the property, not located in a floodplain.
Okay, would you like to add to that, or
No, it's good.
we're good?
Nailed it.
Okay, commissioners, questions, concerns?
Yes, I have a question. The, a holding and training facility for wild horses, is that going to be for private use or commercial use?
Okay. I'm representing the National Mustang Association of Colorado.
Can
And
you
You speak up,
close
please,
to your-
closer to the microphone. Thank you.
Hi, I represent the National Mustang Association of Colorado, and Lori's family has graciously offered to donate the 10 acres for our nonprofit. We do promote the proper herd management and welfare of horses, and so we're looking at using that 10 acres as a holding and training facility. One of our challenges right now in rescuing horses is that we don't have facilities or trainers to place those horses with as they are being habituated and then potentially moved to adoptive homes or sanctuaries.
So I heard the phrase nonprofit, so I'm assuming even though your work benefits other people and some people may be paying for your services, I don't know, but the fact that you're a nonprofit, I'm going to make the leap in conclusion that this is not for commercial purposes.
No, it's a nonprofit business.
Okay.
I'd agree with that. How many horses are you planning to have there?
We put together a rough design based on what we could hold for 10 acres, and we're thinking somewhere between 25 and 31 as a maximum that could be held there. We haven't had that number of horses collected at one time. There's a number of reasons why. Is one, we have to be able to have the finances to support them, which is a limiting factor for how many we can acquire at a time. Our main project right now is with Mesa Verde National Park. So we're dependent on how many they can round up per year as well. Last year they were able to round up 9.
9 horses. And you said you can hold how many, 30?
So we're planning, our long-term strategy is to plan up to 30. Yeah.
Okay,
That's a
So-
lot for 10 acres.
I think it is. So what happens when 31 comes?
Or 30, 31, I mean, we've got, and you're welcome to see kind of our proposal, like our initial mapping of it, that we could potentially have that on there. If we have this out for some experts to look at, to come back, and they may come back and say, no, you're only going to be able to do 20, and then that's all we would do.
Okay.
So some of that information is still
So
in process.
there's a maximum, let's say 20 or 30, depending on
Depending
the
on
professional.
feedback from,
Okay.
right.
So when that exceeds that, what happens to the other ones? Are they given away?
We're not able to acquire them on, so we would, if we have some, we would have to do them directly to another location or not accept them.
Okay.
This year, because we don't have the facilities and ability to take horses on, we have expressed to the park that even if they round horses up for us, which they're in a pause with the budget cuts, if they were able to round, some horses up for us. We would not be taking any ownership of them, but we would facilitate their movement from the park directly into an adopter or a sanctuary. We would help
Okay.
assist
Or
with that.
some sort of relocation.
Right.
Okay.
Would you do me a favor and tell me again the name of your organization?
It's the National Mustang Association of Colorado.
Thank you.
Does the association do inspections on the facility?
Well, we would be owning the facility.
I understand that, but if you're part of the state association, is there a state representative that certifies the holding area to meet their standards and then do inspections to make sure that it's kept up to their standards?
We would welcome a agency to come in and audit us. We have never, I'm going to just say NMA because it's shorter to say. We've been in business for 30 years plus, and we've never had a holding facility. But it's getting harder and harder to operate without one. And there are so many horses out there that are starving and going to kill pens. And so it's all a new thing, but we would definitely welcome an inspection at any time.
So it's part of a state association, but there is no state requirements or regulations or oversight?
It's the terminology, I might not be understanding what you mean by state. It's not part of the state. The organization is an independent organization.
Is there any permitting through any part of the association? Or you just say you're part of it and you join? I don't know if there's any requirements you're meeting, or if you guys just make it up and go as along as you go, or if there's some guidelines, or
Is there
who
licensing?
oversees the organization?
Yeah, is there licensing?
Once we do the facility, we probably, I guess I can't answer that without looking into, because we haven't gone down that road yet, but the facility may need to be licensed. I will definitely dig into that.
Okay. Yeah, I know nothing about it, so that's why I'm asking.
I mean,
because-
right now, we're set up with the, state as a nonprofit business, and there's guidelines that we put together around that to run our own business, but that's
No
like
state,
any other nonprofit.
no state oversight.
Right.
Okay.
Right, there is no state oversight for what we have had to do. I mean, there's certain things you have to comply with for transferring horses and doing that sort of thing, but as far as the state oversight.
And who makes those requirements?
So there's, you have to have the brand inspection and different things, and Coggins testing and different things that have to be done to just move horses.
Okay. Okay, but that's not a state.
That's not a state,
Okay.
no.
I have a question. So basically what we're doing here is we're knocking 10 acres off of this piece of property. And it's private use. So why are we even considering what they're gonna do with the property? Because that's not what the application's for. They're not for a PUC or anything like that. I'm just curious.
We're gonna rezone it.
I understand, but we're doing 10-acre agriculture.
10 acre and the remaining will be.
Right, I understand
Okay,
that, but
We just need to make sure what the operation is to see if it goes beyond agriculture or
okay,
some other level of zoning. So that was my only curiosity.
okay. I'm just curious because like I said, if it's privately owned, at this point, I mean, I understand that if you do this and it's 10 acres and then you come in and put in some kind of commercial and you didn't apply for it, then it's out of compliance.
Right.
But right now, it wouldn't be out of compliance because they don't have the horse rescue unit. And we're not here to consider that. We're here to consider if they can subdivide this 10 acres, is the way I see it.
So it is a subdivision because we're splitting the property, right, 10 acres out
Just-
of the 160.
right,
So that
that's-
in itself would have to come to us.
No, I understand that. I'm not
Oh,
saying,
oh,
But that's it.
but that's all we're here for, is to
Right.
see if they can subdivide this into the 10 acres.
Right.
We're not here to say whether they can do it because they're gonna put a horse
True.
rescue in there, or,
An orchard, whatever, yeah.
because basically what they're proposing is agricultural, 10 acres agricultural. So that's what we're here to propose, not what they do with it.
True.
Because if they come in, like I said, and they put in a commercial, they're out of compliance.
Right.
Because that's not what we're voting on.
Right, we're only here to vote for the
We're only here to vote on this. We're
the
not here
10
to
acre,
vote
right.
whether or not they can
And
put.
I think you're correct,
Well, I'm
in
just.
the sense that, right, what they do
Yeah,
on the 10
and
acres.
I mean, I
is-
understand. We want to know what they're going to do with it, but again, it's not commercial.
Right.
So, just my thoughts. Sorry.
I get it, no, that's a good question.
And just to clarify, non-profits can need to be zoned commercial in certain instances.
That's true too. It could
Just
have a
because you say
and be
nonprofit
commercial.
or that you're a church doesn't always just cut you out of land use.
Yeah, no, I understand that, but what I'm saying is right now, we're just doing the land use code, not what the property's going to.
Right, and the rezoning part is the only part which is for AR 3-9,
Right.
or 10 to 34,
But I
correct?
think by asking these questions, we have determined that it is not going to be a commercial enterprise, as
No,
Commissioner
I
Lynch, yeah.
I totally
brought it,
get it.
Yeah. So, okay,
I'm just trying to make sure that. correctly.
Keep us on track, Ted.
Yeah.
keep us on our toes, keep us on our toes. Okay, if I have no further discussion, we'll open it up for public comment. Anybody wishing to speak for or against this, please come to the podium, state your name and address for the record. There you go, lights on.
Okay. Hi, I'm Barb Terrell. I live at 11305 Road 20. And I think what you mentioned was really applicable. That is a 10-acre lot. We live just right down the road, and our concerns more are about, are you planning on dividing the rest of that property up, and is it going to be a subdivision?
No.
Oh, sorry.
No.
I apologize.
Okay.
So that's my question. I sent some questions in earlier, and the organization graciously answered everything. So I just want to mention that light pollution for us is really important, and so we just ask that you keep the lights low or motion censored, because right now, I'm afraid I see lights from Mr. Douglas's gate coming into our bedroom and living room right now because they're so bright. So we just want to make sure that if we can lower those down, I think that would be fine. And again, that's very gracious of the Douglas family to go ahead and donate the 10 acres for the organization. That's
Okay.
it. Thank you.
Thank you.
Hello, my name is Eric Terrell, but I am reading an email, a letter from a neighbor of ours who could not attend. That neighbor is Patricia Lee, and her address 13085 Road 20. So I'm again reading her letter. My husband and I own a home at 13085 Road 20, and have major concerns about the proposed project. Despite seeing some good points in it, several important details are missing that should be expressly stated. Number one, secure containment. Given the history of dogs and horses repeatedly running loose from both the Douglas property and that of the former occupants of 11092 Road 20, any renewed escapes must be prevented. A new sturdy fence runs along the road front and sides of the present Douglas family parcel, but does that fence completely enclose the property? Canyons of the ancients' land wraps around the back, and any fence there is not visible from Road 20. The concern is whether the animals can get into BLM land, possibly dispersing from there. Also, what will be done to prevent the freeing of horses via gates? The stallion that roamed for miles from the Douglas property and 11092 Road 20 also got into private properties and impregnated at least 2 mares miles away from the Douglas home. The horse was caught in the act, so there's no question about which horse did it. Number of animals. NMACO implied that 50 horses could be held on 10 acres, and that if the Ute Mountain horses are held, that would be another 600. What is the maximum number of horses at any given time going to be? Is this number a genuine permanent capacity that cannot be exceeded? Full project scope. Besides the Mesa Verde 50, just how many and from where will any other horses be brought? Negative impacts to residents, human and wildlife. Of immediate concern is increased human vehicle traffic. If the facility is indeed a small one without public visitors, traffic volume might not increase much. However, if it is used for promotional, fundraising, commercial, or PR purposes, the noise, traffic, and trespassing potential rises. Increased traffic, including horse trailers, would affect all of roads 20, 21, M, N, and P, plus others, to a lesser extent. Which is it going to be? A genuine training site?
I'm going to have to interrupt you. Your 3 minutes are up. Thank you.
Thank you.
Hi, my name's, is that on?
There you go.
My name's Jeff Woodbury. I live on 1150 11588 Road 20, and we have been in communication with a representative from NMACO on a couple of occasions. She's answered a lot of questions, been very forthcoming about her plans. My main concern is the increased traffic along the road from large numbers of visitors, potential adoptees, and everything else surrounding, say, a maximum of 30 horses out there. It takes about a year to bring them to the point, if they are trainable, if they're gentle, if they can be gentled and adoptable, it takes about a year. I don't know how many visitations it requires for potential adopters before a horse finally leaves the place. And so it could be quite a bit of traffic down there, and I'm just wondering if there are any traffic analyses that are required for a project with a scope like this. Thank you.
Thank you. Anyone else? Okay, we're going to close the public comment and bring it back to the commissioners. There were some good questions when they talked about lighting. You're not going to have a building or anything out there, are you?
So, yeah, so I could talk to that.
Bring it a little closer, a little closer. Come on, give us that voice.
Sorry.
Give us that voice. Don't be shy.
The facility does need lighting for safety and
Okay.
different things. I mean, we don't need excessive lighting. It's not going to be like an arena that has,
Okay.
floodlights and things of that nature. But
Okay.
we are looking as part of the structures to have a house there for a trainer and somebody to maintain the horses. So they are on site,
Okay.
24/7, basically. Horses are used to the dark, and so they're not going, a lot of lighting is not going to be intrusive.
Okay.
And we would look at that in our design to make the lighting as least intrusive as possible
Okay.
for not only animals and humans, both, so.
Okay, good enough. And it is going to be fenced, obviously.
Right, and what we have is and it meets the BLM requirements of fencing as well. It's a metal fence that would do the perimeter And then there would be inside fencing as well, so you actually have a double fencing.
Okay.
And then parts of Lori's family property also has fencing too. So we feel our containment would be sufficient, or more than sufficient, for keeping the horses contained.
In regard to traffic, can you tell us what you might anticipate the normal traffic would be and the peak traffic would be?
I'm anticipating that it is going to be minimal. We have, trailers that will bring them in. We can bring multiple horses in one trailer. The one that we own will hold 6 to 8 horses in one transport in. It takes, 3 to 6 months to train a horse, and during that time, you usually don't have anybody adopting, wanting to adopt. We don't even advertise for their adoption until they're ready to be adopted. And at that point, it's usually 1 or 2 people that are looking at them to adopting. So it's not how you might think about like how the BLM does adoptions. We're not doing this massive, like here's a campaign for adopting. It's put on Facebook, and it's very individual for someone to come up, and they have an application they have to do. There's a screening before they even see the horse and come up to that stage. What we're looking at is if the horses are held for a year and they're not adoptable, then we would turn them into a sanctuary if one is available. They're just getting very hard to find sanctuaries. So traffic is, we're going to have a vet come up occasionally, a farrier. We'll have a person on site. There's not going to be a bunch of volunteers coming up to feed, twice a day, so you're not going to see a lot of that traffic. I don't expect it to be excessive. We're obviously, our board members are obviously going to check and make sure things are being run properly when it's.
So it sounds like what you're telling us is that when the horses are brought in, they're going to be brought in large groups per trailer. So the maximum would be 3 trailer loads, at 8 or 9 per trailer load. That would be an unusual circumstance, I'm guessing. Is that correct?
Right, so it depends on the size of the band, because we like to keep them intact as much as possible. So if the band is only 6 horses, then it's 1 trip.
Yeah, and then in terms of when they're adopted, because they're all unique and individual, they don't all get through the program at the same time. So it's not like you've got every one of them being adopted at the same time. It's like some are faster than others, and so you end up spreading out the visits by potential adopters. Is that correct?
That is very true, yes.
Okay. Thank you.
Okay, anything else? Then I will entertain a motion.
I move to recommend to the Board of County Commissioners to approve a proposed 10-acre single lot development and AR 10-34 rezoning application submitted by Douglas Family Trust, agent Lori Tuntlin, based on the following. The proposed use is in conformity with the code. The proposed use shall not generate any significant adverse impacts on other property in the area, and public utilities and services are available or can be made available to support uses consistent with the proposed zoning.
I'll second.
Okay, we have a motion and a second. No other discussion. We'll call for the vote.
Commissioner Hernandez,
Aye?
Commissioner Newgard,
Aye.
Commissioner Lynch,
Aye.
Commissioner Armstrong,
Aye.
Commissioner Doyle.
Aye.
Okay, motion carried. Thank you, congratulations. Good luck. Get a drink first. Okay, number 4. Notice
Commissioner,
is hereby given
Wait,
that the Montezuma
roll call.
County... Oops, sorry.
roll call. Commissioner Hernandez,
Here.
Commissioner Newgard,
Here.
Commissioner Lynch,
Here.
Commissioner Armstrong,
Here.
Commissioner Doyle.
I knew that.
You were just testing him.
Yeah, I was being tested. Okay, number 4. Notice is hereby given that the Montezuma County Planning Commission, Zoning Commission, will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed 4-lot moderate subdivision and rezoning application submitted by Ellis Lewis on property located at 14171 Road 36.75, Mancos, Colorado, consisting of 39.66 acres, more or less, located south and west of Highway 184, situated in Section 34, Township 37 North, Range 14 west of the New Mexico Prime Meridian. This is a public hearing. Was the public notice published?
Yes, it was.
Was evidence of letters to the adjoining neighbors and mineral owners submitted?
Yes.
Was a sign posted?
Yes.
Okay, we have the applicant here. Department
Yes.
findings, please.
So the applicant proposes to create a 4-lot moderate subdivision on varying size parcels. A reconnaissance geologic survey was submitted on March 24th, 2021 by David Gonzalez. Surrounding properties consist of residential, Summit Lake Reservoir, BLM, and BIA lands. There is an existing driveway access off of Road 36.75. The highway access is Road 37 to Road P2 and P3. Existing Road P1 has been ruled by the court as a private road, not accessible to 36.75. Empire Electric provides power to the property. Montezuma Water has a 2-inch main line on the west side of Road 36.75 and currently provides water to the existing property and has water available for 3 additional 5/8-inch meters. No irrigation on the property. Wildfire Adaptive recommends a waiver for the property. Weed Department recommends a waiver on the property as well. The property, the Summit Lake area is prone to high water. The lake restriction is that nothing be built within 50 feet of the high water level. Covenants will be required.
Okay. You have anything to add to that? I'm sorry, say again? Anything to add to that?
Yes. First, I have a question for Mr. Haley, based upon...
Could you turn on your
Yeah,
microphone?
and speak closer there, too. Yeah,
Sorry about
yeah,
that.
there you go. Bring it towards you, yeah. Bring it towards you, the mic.
Okay.
Thank you.
My apologies, I didn't put my hearing aids in, so I'm a little handicapped. But y'all may recall that in late 2020, early 2021, Mr. Haley claimed that I was in violation of the land use code. And so his initial claim was that because the fire damaged replacement home was closer than 30 feet or within the easement requirement setback. And then subsequently, he claimed that I was in violation because there were 4 houses on the 40-acre parcel. Okay, those 2 claims, my question to Mr. Haley today is, do you believe that I am in violation of the land use code, yes or no?
Yes.
Yes? That was a yes?
Yes.
Could you please tell me why?
Because at the time that you rebuilt the house to the north, you didn't stay within the original footprint. You moved the location, you increased the size of the building, and you didn't meet the setback requirements on the north end. And subsequently, the second house burned down. I didn't really do any research on that. More than 2 houses is not allowed on any parcel per the land use code unless you get permitted.
Okay, in response to the 2-house issue, the land use code specifically and Colorado law as well provide that any land use that's in place when the land use code was adopted in 1998 is not subject to the permit requirements. That's the clear language of the law and the land use code. So that the 4 houses were not and are not a violation of the land use code because they're expressly excluded. The second issue that he raised about the house being too close to the property line, this matter came before the county commission. The county commission approved that house in that location. Now, we moved the house approximately 15 feet from its original location so that we could comply with the 20-foot setback from the septic tank. Now, there's nothing in the land use code that says moving that house 15 feet is a violation. So that was not a violation either. Furthermore, if you look at the land use code, if Mr. Haley would pull it up for us, please, section 9103. It's on the next to the last page of the land use code. And Mr. Haley was fairly new in his position. So my suspicion is that he didn't get to the next to the last page. And if you read that one right there, it says, scroll up a little bit. Where are you, 2003?
What section would you like?
Pardon?
What section would you like?
9003, 9103. 9103. Exemptions. Well, I can't read that. Continuation. Yeah. Well, I have it down here, the land use code. Here it is, on page 80. A non-conforming use or non-single family structure which has been destroyed or damaged by fire, explosion, flood, act of God, or a public enemy to the extent of 50% or more of its market value shall thereafter conform to the provisions of Chapter 2. Now, this is a portion of the land use code that Mr. Hernandez may recall Mr. Haley quoted as in the past. Now, the semicolon, it says, comma, or if a damaged building was devoted solely to a single family use, such building may be restored to the same non-conforming use as existed before such damage, as long as a non-conforming use is not enlarged or extended. Now, he claims that the house is larger. The house is less than 800 square feet. It was not enlarged. The reason it was created at 800 square feet, because that was the size of the dwelling that burned. And my understanding, I didn't know the land use code at that point, but I did know that I was dealing with the State Farm Insurance, and I understand that they were demanding that I build a house of the same square footage of the house that burned, and that's what we did. That house is not larger than the preceding house.
But it is moved. It's not in the exact same location.
Well, we couldn't put it in the same location. We had to move it 15 feet to get back off of the septic tank.
And so that created the setback issue? Is that what I'm
So
hearing?
there's the house in 2010. And there's the house in 2024. And I don't know why we're going over this
Yeah, I mean,
again.
Yeah.
He had to get a variance.
Yep.
He obviously moved it.
Yep.
It's twice
Well,
as big,
okay,
and that's my
yeah.
premise from the
Yeah,
start.
Yeah, okay. And my question is, Don, if we have a piece of property and an application in front of us that is not in compliance, should that property not become compliant first?
He is in the process of getting compliant with subdividing and having no more than 2 residences on any parcel.
But you have a setback issue, right?
That has been cured by a variance.
Oh, it's been cured by variance.
In the
Okay,
past.
Okay, then
And
we will
all,
continue.
and all this, any septic system issues about crossing boundary lines, those have all been taken care of.
Okay,
There's no issues
Okay.
from any of those standpoints.
okay. Okay, then we're gonna continue with our discussion. Commissioners, do we have anything before we open it up for public comment? Questions?
Basically, right now, we're just trying to make it to where he's legal, I mean, by doing the lots.
Pardon me again?
We're just trying to make it to where he's in conformity by doing the 4 lots.
Correct, and let me get it to it here.
And there's his sketch that was submitted. Yeah.
Right, so there's an existing house, the other existing house, and these are on Lot 1, which extends out into the lake. Lot 2 is down here, contains this existing house. This little peninsula sticks down here. The dotted line is the setback required by the Summit Lake Irrigation Company, no build area. That's what this dotted line here is. Lot 3 contains his residence right there, and Lot 4 would be mostly in the lake with this part. Currently, there's just a tractor shed on it.
36.
So that parcel is 20 acres. Lot 4 is 20 acres. Lot 3 is 3.2, I believe. It's probably, it's right on it. Lot 1 is the 7 acres, just across the top. Lot 2 is now 10 acres. So,
Yeah, 10 acres. Okay.
so let's just be clear on one thing here.
Okay.
The 4 houses were not and are not a violation of the land use code, because the 4 houses were there before the land use code was there.
They're grandfathered, okay.
They're grandfathered.
Okay.
And as regards.
We're here to talk about your 4-lot subdivision. That's what we're coming.
I'm sorry?
We're here to talk about your 4-lot subdivision.
Absolutely.
That's what we're here.
Absolutely.
Okay.
And-
So,
and-
do we have
and the reason I'm here is because Mr. Haley made those 2, we now know, false claims, and said to me, you are in violation of the land use code. You are subject to civil and criminal penalties. You must do a subdivision or a planned unit development you cannot do a subdivision because your houses are too close together. Now, I doubt that those two houses are too close together, but it's a moot point. We resolved that by putting those two houses on Lot 1, as you see up there.
Okay.
There's no
Okay.
stipulation on distance between houses.
That's right.
Yeah, that's because as long as they meet setbacks, they're fine.
Yeah.
Yeah. Okay, we're gonna move forward. We're gonna move forward with this.
Okay, so but you do understand that the county commission approved that location of that house.
On the north lot line.
And therefore, neither of those two claims were valid. Neither. They weren't valid then, and they're not valid today. I am not in violation of the land use code.
Okay, that's not.
However,
Okay.
I have lived for 4 years under the threat of criminal prosecution and grotesque civil fines on the basis of the violations of the land use code are by the county. The county violated the land use code. The other aspect here is the land use code expressly precludes a subsequent director like Mr. Haley changing a decision of a prior, of decisions made under the land use code. Now, keep in mind that in 2016, after that first house burned, I was dealing with the insurance company. And we put the house essentially as close to the original location as we could.
Okay, okay.
And there's absolutely nothing in the code that says it has to be in the same location. We did that to satisfy the land use code, to get into compliance. And keep in mind that the county commission approved that house in that location in 2018. So that was, neither of those are violations.
Okay, so we don't need to discuss it. We don't need to discuss this. It's not part of our application in front of us. We don't need to discuss it, Mr. Ellis, okay? We want to move forward with what we have in front of us, okay? That's what we're going to do. All right, so commissioners, do we have any other discussion before we open it up? Okay, I want to be perfectly clear, though, Don, on the water issue, because I remember this last time, the access was an issue. We had Road P, which is a private road, right, and cannot touch, or does not touch, 36.75. Is that true? It's a red road. Everything's red in here.
Right, everything's red in there.
So access to this property comes from P3?
P2 and P3 intersect with 36.75.
Okay, and those are both red roads, public, non-maintained.
Correct.
Okay,
Okay.
okay, I'm good with that.
So regarding the road issue, first of all, I would make one correction to the packet that you have. In that last section, which is the history of the Summit Lake area, in the second sentence, there's a date error. Because that sentence says that Mr. Gentry conveyed property to Sisler, and the document I gave you said 1975. 1975 was when Bud and Kathy Rousseau acquired that property. That original conveyance was 1970. And keep in mind that I have this before me if you want to review it, but that document expressly retains to the heirs and assigns of Mr. Gentry permanent access to Summit Lake. Okay, furthermore,
Okay,
we have the opinion of the county attorney. This is dated August 11, 2021.
Why are we talking about Summit Lake? I don't care about Summit Lake. I don't care about Summit Lake, unless you're gonna access this property by boat. I'm talking about the physical access you're gonna drive on.
Yes.
Okay,
yes,
and that was my
absolutely.
question to Don, which he remedied, so we're clear, that's done, it's
Okay.
over. We have
Very-
access. We have access to the point, Mr. Ellis, I don't need any further discussion from you on that. You're digging yourself a hole here.
You say access?
We do, we have it.
It's the issue.
We have
You
it. P1,
acknowledge I have
P1,
access?
P3, and P2. They both touch 36.75. That's it, we're done.
I'm sorry, would you say that again, please? I'm hard of hearing.
P3 and P2 touch 36.75. There's your access. They are public roads, they're red roads, they're not maintained, but they're public road. So-
On the contrary, sir, there is an express easement. First of all, Mr. Gentry retained easements on all of the properties encompassed by P1 and P3 out to 36.75. The 1970 conveyance predates that. And in that document where he retains access for his heirs and assigns. There is this express deed that provides access to my property on 36.75 and on road P3.
Okay.
Okay? Which is contrary to what you, if I understood what you just said.
No, that's what I said.
Okay.
P3 does touch it.
And let me tell you what the county attorney has said about this issue. It's certainly relevant. This is a communication to Mr. Boswell that they provided in discovery. And it says this: Road P1 is not a part of Montezuma County's primary or secondary road system. In other words, Montezuma County does not consider Road P1 to be a county road. Who owns P1 is likely dependent on a variety of factors, including how long the road has been used by the public, and whether the road was the product of some sort of private grant or easement. Now, these roads are all, except for those earliest 70, in 1986, I believe, Empire brought electric in there, and Mr. Gentry subdivided the land. Each one of those parcels bears the language for two easements. First of all, it grants an easement from that property directly out to the public highway system. Secondly, there's a second easement, and that second easement is for utilities and a roadway. Now, Mr. Gentry retained 40 acres that were only accessible through those roads where he retained those easements. It would be a violation of the law to sell a piece of ground that you can't access the public highway system. And so Mr. Gentry retained those rights. In 1984, he conveyed that 40-acre parcel to his daughter, Zelpha Gentry. Zelpha Gentry was my dear friend and partner in life.
Mr. Chair, I'm not sure that the history is going to help us with this.
I'm thinking the same
Yeah.
thing,
This-
right.
with
This
this
is all
permit.
irrelevant to us.
Right,
It's all
so-
relevant. So we're going to carry on, okay? I'm going to ask you to be quiet right now. We're going to carry on with this, because we still have
That's
public
this-
comment to do.
Is when you take your comments from the public,
Okay.
that you will afford me an opportunity to respond. Can you do that?
Yes, we will record them, yes.
Thank you.
Okay, so we're going to open this up for public
But,
discussion. I'm sorry.
Mr. Chair, before you do that, I just have
We have
one more.
one more question.
One more question for Mr. Haley. You mentioned that, first of all, the road P1 is a private road, correct?
Correct, per the court.
Yeah. And then the other thing that I thought I heard you say was, with the way this has been subdivided and with the past history, as after this particular application, there will be no non-compliance existing, correct?
Correct.
Okay. I'm good to go.
Okay. Anything else? We good? Okay, we're going to open it up for public comment now.
I'm really.
No.
Can you speak into the
No, we're not.
microphone,
Okay,
please?
okay. We're going to open it up for public comment. Anybody wishing to speak for or against, please come to the podium, state your name and address.
My name is Ray Boswell. I live at 36800 Road P.1, adjacent to Mr. Lewis's property. This is the third time we've been here on a question of subdividing Mr. Lewis's property. And for us, for the residents here, this will be the fifth time, if you count in the times we've also had to appear before the Board of County Commissioners. Mr. Lewis isn't just trying to bring his property into compliance with the code. What he wants to do is add more houses to the property. He has a single lot currently with 4 houses on it. The land use code allows for 1 house and 1 accessory dwelling unit, which is a guest or caretaker unit. Mr. Lewis uses his for rentals. The county has previously agreed to subdivide his property with a plan that would divide the property into 4 lots, but with the stipulation and deed restrictions on it that would not allow any more houses. Mr. Lewis would not accept that as an alternative. It was a reasonable compromise by the county. But adding 3 more lots and as many as 4 more houses to that would not be a reasonable thing. The CDOT, in the 2 previous times we've been here, had expressed their position to the county that Road 37, where it comes off of State Road 184, is too dangerous an intersection to allow further development. That may have changed, but the last time we were here, we had a statement from CDOT that they would not approve a development, and that they would require, or the county would require, that CDOT do approve it before any further development back there be taken. Most of the properties in Summit Lake East have a single house on their property, but a number of them are large enough they could add another accessory dwelling unit. That would add further to the burden of traffic on those 3 narrow roads that make up, that he feels constitute access to his property. It's important to note that you talk about having 2 roads that connect to 3675. Those are 15-foot roads. The land use code requires a 30-foot road to connect a subdivision to the state road or to a county road. P3 and P2 are both 15-foot roads built on 30-foot easements. The only reason P1 is out of the question now is because we filed suit against Mr. Lewis, and the court agreed that P.1 is in fact a private road and that he has no easement on it. It would be unfair for every resident on P2 or residents on P2 and P3 to have to file that same lawsuit that we did to get the county to acknowledge these are private roads. They don't provide public access to anywhere. They are not through roads. You can't get to Summit Lake, and you cannot get to public land. You can only get to the other residents that live there. So the public he refers to that's been using these roads for 20 years is the people who live there, no one else. You can't get there through Summit Lake East. You can't get anywhere except to your own residences. The whole idea that it's a public right-of-way, that's what we determined in court this past May. Each of the roads, P2, P3, and P1, cross private properties. Whether or not it's, without the county attorney here, it's even questionable or not, whether or not Mr. Lewis can grant easements, divide his property into 4 lots and grant easements to each of those people to cross all these other people's property that have easements without their permission. I'm not a lawyer, but I think it would be foolish to make the assumption that he could do that without getting some legal advice on that question as well. That's all I have.
Okay, thank you. Next.
No, please.
No. Next.
My name is Daniel Ben Locker. I live on the corner of 36.75 and P3. My address is 3675 4 Road P3. I don't know the law or the land use code. I'm a friend of Mr. Ellis and a church member and a neighbor. My concerns specifically are in regards to the discussion of P3 and P2 being used to access that property. And I invite you all to drive down P2 before saying that. It's quite a rough road, and both of those roads, P2 and P3, are very narrow roads. Because P3 is not as rough as P2, all of the individuals who access that area in that subdivision drive on P3 and around where I live, my property. My concerns specifically are in regards to more homes being developed on the property. I have no concern with the property being brought up to code or land use code. My concerns are that there are currently 3, soon to be 4 toddlers that live on P3. And I speak as well after speaking with my neighbors about this and their concerns about our little kids playing out on the road. While it is already, you know, driving down that road, hard to see what's in front of you because of the hills and the bushes on the sides of the road. And have had a few narrow mishaps of my toddler on her bicycle. So yeah, basically those are my concerns, and I would hope that if more homes are approved to be developed, that the P2 be at least in consideration as an access, because right now it's not being used to access that area, and the road would need to be improved, in my opinion. Yeah, that is all.
Okay, thank you. Next.
Hello, my name's Ari Skyhorse. I live at 36985 Road P.1. I'd just like to point out that P.1 is the road that myself and several neighbors live on, and that was actually blocked by Mr. Lewis. So that has no connection whatsoever, and that was done, I guess, in retaliation for the findings of its access or lack thereof. So currently that's blocked, and that was done by Mr. Lewis. I'd also like to just read a letter written by my wife, who wasn't able to make it this evening. She says, as a neighbor of Mr. Ellis Lewis, I'm disappointed he has yet again decided to request a subdivision in Summit Lake East community. I am writing to staunchly oppose subdivision on Mr. Lewis's property. This has been denied before and nothing has changed. I see this as Mr. Lewis's attempt at wasting precious time, energy, and resources on the part of his neighbors and on the part of the Planning Commission. Mr. Lewis has not followed the land use code in the past by building rental properties without permission and incorrect setbacks. The county was kind enough to offer variances for these out-of-compliance buildings. However, I caution the county, the more you give Mr. Lewis, the more he is going to take. CDOT has noted before that any additional traffic due to the subdivision would be unsafe due to blind turn that exists before Road 37. In order to fix this, a turn lane would need to be added. CDOT did not approve this subdivision. Mr. Lewis has shown a lack of ability to compromise and work with his neighbors. He is dismissive of other opinions and factual information. He continues to claim that 3 roads meet requirements for the subdivision, and these roads do not, as previously mentioned. He continues to claim he has deeded easements, which he does not. I'm aware of the need of housing in Montezuma County. However, I would highly encourage the Planning Commission to not approve or give any leniency to Mr. Lewis and his proposal. As he has shown time and time again, he cannot be trusted to follow or adhere to the laws and the rulings of this county. So I would just like to also make my own statement along that. Back to previous interactions as brought up by Mr. Boswell. This is our 5th time here regarding basically the same issue. And my concern is that if there is any leniency given, as he's proven to you as well, he will stretch the law as much as he likes, and then come in here and argue it to the nth degree, and it's a waste of your all's time as well as ours.
Thank you.
Thank you.
Next.
My name is Dan Green at 36855 Road P.1. And all I wanted to mention is when this first started, when we first discovered that Ellis wanted to build a subdivision, he was kind enough to have a meeting of the neighbors, and we all went over to his property, and he explained what he wanted to do. One of the things he did is he walked us around and showed us where these 3 new properties for houses would be if he was able to build them right on the edge of the lake. And the main concern that I heard from the people who were at that meeting was that, you know, these properties that could be built on were in the floodplain zone, right there on the edge of the lake. I mean, if you looked at some of the floodplain maps, I don't know who they were published by, they were right there. That was an issue that they were worried about. Probably the biggest issue was the additional traffic that would come in on P1. And then the other fact that if P1 were upgraded to a county road, you're talking about moving water meters and moving electric outlets, and, you know, basically taking a chunk out of everybody's property on that road to make it a county road. So that was what people were upset about, and that's just my understanding. I was at another meeting after that, and I do believe that road access and traffic, plus the floodplains, were the main concern.
Yep, thank you. Do we have any other? Okay, we're going to close this public comment and bring it back to the commissioners for questions, and I have some.
Chairman?
Go ahead.
Yeah, our screen's blacked out, and this letter that we received yesterday afternoon from CDOT, I got a hard copy.
That's
Let
one
me
of the
just
questions.
read it to you here. It is from Jennifer Allison, Region 5 Traffic Engineer. She states that on 12/7/22, CDOT received an access permit application from Ellis Lewis Revocable Trust for an additional 2 single-family homes on parcel 5361344000006. As part of the application process, a turning movement traffic count report dated 2/3/23 conducted by PST Engineering LLC was submitted to CDOT that shows the existing traffic at State Highway 184 and County Road 37 intersection already warrants the need for a left turn deceleration lane without this additional development. On 3/6/25, CDOT received a development referral review request from Montezuma County regarding a proposed 4-lot moderate subdivision and rezoning application submitted by Mr. Ellis Lewis. Based on the information provided to CDOT from the 2022 access permit application, CDOT's stance regarding the warranted safety improvements at the intersection of State Highway 184 and County Road 37 remains the same. Montezuma County has authority over land use, so the decision on the proposed land use is ultimately the county's decision. It is also Montezuma County's responsibility to ensure that all the required safety improvements are in place prior to additional land use approvals. Therefore, it is CDOT's recommendation that the safety improvements be in place prior to any additional land use approvals for the benefit of Montezuma County residents. This letter serves as CDOT's notification to Montezuma County that the existing development at the intersection of State Highway 184 and County Road 37 warrants auxiliary lanes, and no further land use approvals should be issued by Montezuma County without the addition of the warranted safety improvements. Reach out with any questions. Sincerely, Jennifer Allison.
Okay, and that's a left-hand turn and a slow-down right turn?
So it states,
So deceleration for
the
right turn?
need for a left turn deceleration lane.
Okay, that's both directions then?
Yeah.
Okay. Okay. That was one of my questions, so. Anything else, guys? No? Okay, so the way I read that, as part of this subdivision, if we approved this subdivision, that would be a condition, that a left-hand turn into 37 and a right-hand deceleration lane be constructed.
It would, you would just have to meet any of their requirements. So as the county has done in the past, we do not apply for access permits for our county roads.
Mhm.
So any development that occurs, we sign a waiver and allow for that person to apply for the access permits with CDOT
To CDOT.
directly. So we have signed with Mr. Ellis Lewis. His was the third waiver that we have signed, maybe the fourth.
By
Subsequent-
waiver, you mean?
The
we're
county waives its right to procuring an access agreement for our county road.
Yet CDOT's
So-
asking for it.
So two of those have been completed, and the developer has actually received the access permit for the county road to the highway.
I'm not following.
This is part of CDOT's new program over the last 3 years, is they want all our county roads to be permitted to their highways. In other words, they want all the traffic studies done for free, they want all the construction done for free, they want all their highways upgraded for free.
Okay, that I understand.
The county is not taking on that responsibility, other than we currently are doing a study, a design, and engineering, and construction in the future for relocating County Road 25 at Highway 184.
I saw that.
The county has agreed to take care of that. That has apparently been overpopulated with traffic for the last 15 years, so.
That weird okay.
Yeah.
So with going
So-
back to this,
So this letter doesn't get super prescriptive on what actually would have to occur. It'd have to be engineered, it'd have to be, so as it stands now,
plus it's
CDOT's allowed too much traffic in that area
on 184.
on the intersection of 37 and 184.
184.
So what happened is 37 used to be the state highway. The big corner used to be the county road.
Oh, yeah.
In the 70s, the county and the state swapped those, and I don't know the history, I just know that it happened. And unfortunately, the county road never got an access out of that area. It's a one-way in, one-way out. Whereas the highway continued on down to the southeast through the BIA land, what they currently have now. That should have continued. That would have relieved all the congestion on that area. That would have extended an intersection further from that right-hand corner on 184, but that didn't happen. Over 50 years, Summit Lake area has all grown up, filled in. So that intersection is what it is. It's not a cheap fix.
Well, yeah, and we were here last month
Yeah.
on basically the same traffic issue. Yeah, okay.
So that's just a brief
So-
history on that.
So with CDOT, with that recommendation, they don't hold that over the county. They're just, that's just a recommendation. That's all it is. Okay. Okay.
Correct.
May I speak?
Okay, so it is a safety issue, but, or safety recommendation, I will
Right.
say, okay. Okay, so.
And consequently, CDOT won't reduce the speed limit on 184 down to 55, even though that's a safety concern, and there's plenty of accidents,
Plenty
but
of
they want to
accidents.
keep traffic
Right.
moving.
Yeah.
Right. Okay.
So it's a catch-22.
Yeah, I see that. So again, okay, so,
John, may I?
no, not yet, not yet, not yet. Okay. And we're gonna have questions. You will answer the questions only, okay? That's what you're gonna do, answer the questions. Gentlemen, I'll let you guys go first.
As far as questions,
Questions? Further questions, comments?
this is a tough one.
Okay.
So, are you gonna know, or? So there's 4 houses on this property, this larger property at this point in time. Are they occupied?
Are they occupied, the houses?
Oh, yes.
Okay.
And if we were to agree to this, would he be able to put on, Don, would he be able to put more houses on there?
Without any restrictions, every parcel is allowed to have 2 residences.
Amen.
Okay, no, not yet. So could we, as commissioners, make that a,
Condition.
condition that a second house cannot be built? A second residence cannot be built? I'm not gonna say a structure, just a second residence. In other words, turning 4 into 8. Could that be a condition?
That would be up to the board.
This board?
Correct.
Okay, so we understand that.
The problem is that it's written in the land use code that you can have 2 homes. So he can come back and argue the point and get our condition taken off.
Maybe, maybe.
Yeah, maybe. But
We could argue it.
Yeah,
Once
you can argue all you want, yeah. Yeah, but we can make that condition, and that
Yes, we can
condition's
make
gonna
that
go
condition, yes.
to the BOCC. See, what I'm trying to do is,
I know what you're trying to say.
okay, is trying to get ahead here, trying to get ahead. here. Because-
Any recommendation you make, one way or another, I mean, if, to approve it
Right.
with conditions, those conditions are stated with the county commissioners.
Correct.
What they do with them
Right.
is their decision.
It's their decision. Yeah. But again, as far as looking at what the traffic concern is here with the neighbors, if we can make that condition, if we even think we want to approve this. You know, and again, the property owner may say, no, I don't even want to think of that.
I totally understand that. I really do. But this is the issue that we've been having for the last 2 years, is that we're,
If you don't speak into the microphones, I can't hear you.
Okay. Well, this is between us right now, yeah.
again, it's us, but each one of us interprets the land use code differently.
Right.
And a lot of things are getting, slipping through. And I know that we're, gonna work on it and try to improve it, but we have to look at what the land use code says today. And
Agreed.
not what we anticipate it to say. or
Agreed.
What we think it should say. So I'm just trying to save some time, but again, I don't really know how to do it because I'm not an attorney. But
Okay.
yeah, I mean, I understand, I think, we should do some conditions, definitely. Road improvement's gonna be one of them, if we pass it. But I'm
Well,
having
that's-
a real
yeah,
hard-
that-
I'm
yeah.
having a real hard time with what's going on.
Yeah.
I mean, he's been out of compliance.
Right.
It's the same thing. I mean, well, we all know.
Okay.
I'm just speaking in public because
Okay, John, you're gonna let me speak?
Not yet,
When we're
not
done.
yet, when we're done, when we're done. Okay, Mike, you have a?
Well, I was trying to find the part of the land use code that might apply to what I wanted to say, and I'm not sure I found it, but in Chapter 5, under the subdivision regulations, subdivision policies, the following shall be the subdivision policies of Montezuma County to guide subdivision of agricultural land. I'm not going to finish that one. To avoid subdivisions that result in unacceptable or unsafe traffic, noise, or dust levels on county roads.
This is a private
We're
road.
talking about that exact problem
Yeah,
Yeah.
tonight.
we're taxing, right, we're taxing those roads.
So
So unless the applicant is willing to improve that road at his cost, and like the gentleman said, you know, could probably move mailboxes, water lines, whatever.
And to minimize conflicts from land subdivisions that will result in significant adverse impacts to adjoining land.
That's the key
Yeah.
right there. That's the key right there.
To guide development so as to provide adequate public facilities without undue cost to the taxpayers of Montezuma County.
Right.
Again, why should we all pay for the roads? Improve so that you can profit.
To avoid development in areas that are unsafe or unsuitable due to natural hazards such as flooding, wildfire, unstable slopes, or due to the unfeasibility of providing basic services such as adequate road access,
There it is.
electricity, potable water, sanitation, telephone, and fire protection.
Okay.
Okay.
Now,
Now, okay, first of all, let me get this out
you
again.
may try to answer these questions that these people posed, which was regarding the access. We already talked about CDOT now, so we know about them.
Now about the road access. This is a legal opinion from now Judge.
Well, you have access to your property on those roads. We're not arguing that. We're arguing the condition of that road. You're putting a burden, or possibly putting a burden on that road if you develop those 4 lots into 4 more residents.
It's not possible. Lot 1 already has 2 houses on it. From a practical standpoint, there are 2 prime locations there, which is where those cabins were before the electricity came in. But let's, regarding the road business, here's the law, and according to the county attorney, this is Colorado Statute CRS 43-2-201. One question that you will likely need to answer at the forefront is whether the road has been used by members of the public for at least 20 years without objection or interruption. If
Mr.
it
Chair,
has,
Mr.
But
Chair.
we're not talking about the public. We're talking about residents that live there.
Yep.
Unless the public's going to fish at Summit Lake, that's the public. We're talking residents. The people have been driving up and down that road for 20 years. It's a private road.
that's not, no, sir. It's not limited to residences. These are red signed roads, and they've been in use for 40 years. 40 years. And
A
according
red,
to-
a red sign road does not necessarily make it public. It does not. It doesn't.
Look at the law. Look at-
No, I'm not going to look at the law because I'm not an attorney. No one up here is an attorney. So we're not looking at the law. If you have something to say as far as answering those questions from those neighbors, that's it.
If those roads have been in use for 20 years,
I know easement, sir. That was my life.
It
An
doesn't
easement,
require-
an easement, especially by prescriptive right, has to be ripened in a court of law.
okay, so if I understand what you're saying that the public doesn't have a right to use these roads? Is that-
No, I'm not saying that. The public they could try to use those roads, but where are they going? They have to have a destination.
No, you can drive around in circles there. But anyway, let's get past that. Let's talk
No.
about,
Mr. Chair.
let's
No.
talk about
The point
this.
is that he has
Okay.
access. That's not.
That's it.
what we're arguing.
Right, the act
So
is
he
right.
What he is stating, we
We are-
already know. You
Right.
have access to your property.
Correct.
You have access to your property. That doesn't mean that you can add more access to it,
More traffic.
more traffic.
Right. That's
all
our
we're saying.
concern.
We're not
That's our
saying that
concern.
you don't have access to your property. You do. So
Right.
I don't know why we're arguing the point of the roads. Because
It's the condition of the roads.
it's the
Yep.
condition.
That's it, the
Okay,
condition.
well, let's go past that. Let's talk about conditions. This is the land use code.
We just read the
Okay.
land use code.
Land use code, section 2022-02.8, section D. P and Z's conditions of approval are limited to those ensuring compliance with the decision criteria. and approval or denial of the plat shall be supported by written findings specifying the provisions, if any, that the plat or plan has failed to address or satisfy. So this is not a blank check. Furthermore, let's look at the law.
No, again, we talked about the law. We're not attorneys. You're not an attorney.
Conditions, I could read the statute and you can't do. Here's
But I'm not an attorney. I'm not going to interpret it that way. I'm not going to interpret it.
229-2203, conditions on land use approvals. This is not the county land, you're subject to the county land use code, you're subject to the laws of the state of Colorado, you're also subject to the laws as expressed by the United States Supreme Court. But let's stop with the state of Colorado, because there's no question whether these proceedings are subject to that law. Would you dispute that?
Yes.
You're not subject to the laws of Colorado?
Yes, we are.
You are, okay. Let's read this.
Why?
Section CRS 292203, conditions on land use approvals. In imposing conditions upon the granting of land use approvals, no local government shall require an owner of private property to dedicate real property to the public, or pay money, or provide services to a public entity in an amount that is determined on an individual and discretionary basis unless there is an essential nexus between the dedication or payment and a legitimate local government interest. And two, the dedication or payment is roughly proportional in both nature and extent to the impact of the proposed use or development of property. Now, can any of you really believe that if I put a house on that 20-acre lot 4, that I should be required to pull a multi-million-dollar left turn lane on the state highway that's a mile away? This is absurd on its face, and you know it.
That's between you and CDOT, not us.
It's a violation of the law.
Right.
It's a violation of the law. This is Colorado law.
Okay.
And it
All right.
comes from.
That's the end of the discussion. I told you we're not talking about law, okay? I'm not an attorney, you're not, nobody here is. So, gentlemen, I will entertain a motion.
Okay. Furthermore, you're talking about CDOT. I received this email from Mr. Haley. Don't stop me.
We are done. We are done, Mr. Ellis. We're done.
No,
We're
I'm
done.
not done.
We're done. Thank you. That's it. We're done.
This is from Region 5. Region 5. You can't stop me from talking. Okay.
Yes, I can, sir. Yes, I can. This is over. This is over. We're not
No.
listening.
Based upon the traffic assessment provided with Mr. Lewis's access permit application, the existing development on Road 37 already meets warrants for auxiliary lanes on State Highway 184. We knew that 5
I'm
years
not
ago.
talking about 184.
Although an addition of an ADU, a dwelling unit, is considered a single-family home based upon trip generation, will not trigger the 20% traffic volume increase needed for a new CDOT access permit.
The end.
That's,
Thank you.
Thank you. Thank you. Thank you. We got it. It's on the record. Thank you. All right. But commissioners,
Mr. Chair, I recommend, let's see, I move that we recommend to the Board of County Commissioners to decline a proposed 4-lot moderate subdivision and rezoning application submitted by Ellis Lewis based on the following. The proposed use is not in conformity with the code. The proposed use shall generate significant adverse impacts on other property in the area. And according to section 5101.2 would not be in compliance with that section.
can you state that section again?
5101.2.
5101.2. Thank you.
Could we add to that, that I think it also would be violating 1201.2 in that it's going to have a significant reduction in neighboring property values.
Okay. Okay, so to be sure, what we have in front of us is the recommendation, a motion to deny. So a yay vote means to deny, a nay vote.
Excuse me, Chairman.
I'm sorry.
Was there a second?
No, I'm just explain this first,
We had a
just
second.
before we get the second. And Ted second, right?
Yeah, I
Okay, Ted second. Okay, so we understand that we don't get mixed up here.
I'm sorry, I didn't mean to interrupt your
That's
discussion.
right,
I just
that's right.
wanted to.
So a deny, a
Yay
yay
is
is for
agreeing
the
with points.
denial. A deny is, right.
Yeah, so I messed up last time.
That's why I want to get it correct.
So
That's why I want to get it
a
correct.
yes is to deny.
Correct.
Okay.
Correct, not yes. Okay, thank you for this.
Thank you.
Thank you.
Thanks.
We'll put it in the record. Okay, we have no further discussion. We're going to call for the vote.
Commissioner Hernandez?
Aye.
Commissioner Neergard? Commissioner Lynch?
Aye.
Commissioner Armstrong?
Aye.
Commissioner Doyle?
Aye.
Okay, the motion has been denied. The application's been denied. You can get with Mr. Haley, and he will give you the,
Am I in violation of the land use code, yes or no?
not our decision.
For 4 years, I've lived under a threat of criminal prosecution
It's fine.
based upon this false allegation. Now, yes or no? Am I in violation of the land use code, yes or no?
I am not in the
We're, that's not for us to discuss. That's not for us to
Per
discuss.
section 9103.2, number 4, if a damaged building was devoted solely to single-family use, such building may be restored to the same non-conforming use as existed before such damage, as long as the non-conforming use is not enlarged or extended.
And it is enlarged.
And it was.
By a picture, okay. Okay, can we have roll call, Don, please? Roll call. Roll call.
Commissioner Hernandez?
Here.
Commissioner Neergard? Commissioner Lynch?
Here.
Commissioner Armstrong?
Here.
Commissioner Doyle? Excuse me,
Thank you.
Public?
Take that too.
we're still continuing our meeting. Please, that's all right, just talk outside, you're fine.
Yeah. Do we have-
You want to go first?
Well, I don't know. Do you want to talk about solar? I've got questions about that. and kind of
Yes,
our
so,
process.
I don't know if all of you are aware, as of Tuesday, the Board of County Commissioners implemented up to a 6-month moratorium on alternate energy, specifically utility scale solar farms. They did not put a moratorium on an existing application that was already previously submitted under our current land use code. So we are still processing that application. It will come before us. It is currently scheduled for our May P&Z meeting, but we are not accepting any more applications.
That'd be May or June, do we know?
May.
May, okay.
So the next step is that the commissioners, planning, P&Z, we need to look at reviewing and addressing not only solar, large-scale solar, we already have oil and gas, but also to include nuclear energy as an alternate fuel energy resource.
Nuclear. You don't have enough water here, trust me. You can't feed a house in Mancus. You don't have enough water for nuke.
They have whole different systems now. You can even have a micropod that runs just your house.
Really?
They're
Don't they have water?
Oh, they're,
They have water.
so they're not micropods, they're mini systems, and they're all self-contained with their own water. Yeah, it's real technology.
What's that called? What did you say it's called?
Nuclear energy,
No, the small stuff.
they're micropods for your house, mini pods.
Okay,
So you can put a plant on like 2.5 acres.
yeah. Holy Moses.
But in addition to that,
Get one by my house.
So in addition to that, which I'm sure that there is more federal and state regulation on that type of energy than we
Yeah.
could ever decide to come up with. But it wouldn't hurt to look into it, but we will be tasked with preparing and adopting a draft section for the land use code in order to address these large-scale utility solar systems, because it was not envisioned back when the high-impact permits were adopted.
Define large use. Acreage, kilowatts, what's defined?
Well, that's.
that's the thing you gotta do.
That's something else. I mean, we have two 2 megawatts and one 5 megawatt system, which are through Empire Electric, which I myself would not say those are utility scale.
Yeah.
They are for our local co-op, but
Has anybody driven out to Pleasant View? and
So-
saw
so the ones we're looking at are those that are like, I would say over 50 megawatts.
Okay, that would tap directly into the grid, the tri-state grid, which is
Correct.
the national tri-state.
They either go to
National-
tri-state,
Okay.
The other one's not tri-state, is it? The one in Pleasant View or Yellow Jacket?
no, I think it's going to somebody else.
Yeah, it's going to somebody else.
Or could go to WAPA. I mean, but it's still the national grid.
Yeah,
The national
Right.
grid, as opposed to the local grid.
right. These are
Yeah.
national.
document I just provided you, I want you to acknowledge the receipt of it.
I have it. It's on record here that we received it, yeah. I got it, Mr. Troy, I got it. Okay, we're good. Thank you. Okay, so that's the difference in, it's gonna be where it goes, as opposed to local,
And that's what we're
local
gonna,
Right.
utility to the national grid.
that's what we need to figure out is, what kind of power grids they are and what size it is. Because it's crazy.
Well, if you generate electricity through solar, it's either gonna be for you, or it's gonna go to Empire Electric, or if it's big enough, it's gonna go to the national grid.
Right.
That's the only three choices it's gonna go.
I think basically what we need to do is just figure out how we're gonna conceive it. How the funding, or not the funding, but the taxes and different things like that. And that's not really our fault, or our thing, but
Right.
If they
No.
want us to
we're gonna have to.
define
Yeah.
it,
Because
yes.
right
So,
now,
the-
right now, these guys are coming in and putting these solar farms in. That's what they're calling them, solar farms.
Solar farms.
So they're paying agricultural rates.
Oh, that's not good.
Of course not.
No, that's not
But
good.
that
Yeah.
can happen, right, Don, here? Isn't that how they do it, or do we have
No.
anything right now in the land use code?
So right now, it does not say where they can or can't go. One point that has been addressed and discussed over the last, month or 6 weeks is irrigated land. Makes no sense. They shouldn't cover that.
Right.
They can cover ag land, and there can be ag land that's nothing but rocks and brush.
Yeah.
Won't even grow grass.
So.
I mean, wild grass.
But there's
Yeah.
nothing in the land use code that says that.
Right, and that's.
what they want us to do.
Right, so that would be something to address along with,
That could get sticky. Now you're telling a property owner that he can't develop his property.
Exactly, so.
so there's property rights on both sides of that coin.
Yep.
Those that do want to lease them and have them on their property, and those that don't.
Mhm.
So talking with our assessor, utility scale solar farms are taxed by the state. The property is still ag land. Any benefits beyond the panels and the electrical lines would be added to the property owner's tax bill, but they are not changed to a commercial tax rate currently.
Okay, currently, okay.
The state keeps making all kinds of changes, or they got tax credits.
Yeah.
They buy and sell on the market. I don't know where those are headed. So basically, we do have a draft that we could start with from Mesa County.
Let's look at that.
It's up to you guys if you want to start looking at that now, but what we don't want to do, don't start looking at it now and try and implement anything from it on an
Till after-
application.
Till after the application. Well, yeah, that's got to go in its own merit.
Right.
Okay.
So I won't get into like all the details of the conversation I had, but I was at the National Planning Conference a couple weeks ago, and there was a session about, it's called the solar binary. And I was at a table with folks in the industry side of it. And I was listening to the presentation, and there's a lot of nuances to these different sorts of definitions of these types of installations. And I was kind of looking at the Mesa County while I was listening to that, and I was trying to have a conversation with the industry folks. And it was clear, like, from their perspective, they didn't even actually understand what the dilemma was with land use codes. So I guess, you know, do we have like a time frame that they want us to have like something figured out? The commissioners? I didn't necessarily hear that from them.
6 months.
Yeah, it's.
Okay.
For the moratorium.
It's only up to 6 months, and we do not want to extend it.
So the other thing that I'm hearing in the community,
Be an applicant.
Oh, okay.
so the other thing I'm hearing in the community is, as you can imagine, it's both sides of this
Yeah.
issue, right?
Oh, yeah, yeah.
So I guess for us, just wanted to talk to you guys about process of like how we start going through and creating this language. And there's plenty of reports. I sent Don a report that I kind of pulled down off of a website that was recommended, and there's some webinars and stuff. So we could do a lot of our own self-study, but I feel like what I'm picking up, and this will lead to another thing I want to talk about, but I think we should take the time to try to do this in a pretty public fashion and invite different stakeholders. And I know that gets tricky, but I feel like if we bring in people that are in the industry and we bring in people that are for it, just generally, right, philosophically, and then those that are against it, and just sort of weigh this out as best we can with all the community input we can, it's going to lead to something that the community is going to be accepting of. And then obviously the attorney will go through it and decide what's legal at the end of the day. So I guess that was just kind of what I wanted to say is like, are we going to do some public meetings around it and have conversations with different stakeholders about it to find the language? Or are we going to just sort of look at a model code from somewhere else and then just do our best with just studying things and talking about it here at a regular meeting?
I mean, I watched the BOCC meeting last Tuesday, and there was pluses and minuses. There are people that spoke for it and against it, you know, so, yeah, getting their input probably wouldn't hurt. Of course, it's typical NIMBY, you know, I don't want it in my backyard,
Well, I think,
you know?
I mean,
Again, what's the benefit to the county, you know?
Yeah,
But
that's-
again,
that's
is
what
that
we
really?
really need to look
Yeah,
at, is
is
what's
that
gonna be
our-
the benefit
Is that
to
our
the
job? Is that our job?
No, that's not our
Yeah,
job. That's
so-
the problem.
Yeah.
That's where my dilemma is with a lot of this stuff, is that, you know, I see things that we're approving and disapproving that are hurting the county. You know, and there's ways I think that we could change the land use code at some point to where it will benefit the county instead of, you know, I mean, not to talk, you know, I mean, you know, I know that Nicus, Colorado is totally against under canvas. I get it. I totally get it. I don't want it in my backyard. But how many jobs was it gonna bring to kids in the summertime?
What, yeah.
How much
They
economy,
discussed that, yeah.
you know, the road improvements, there was so much. I mean, I get it, but legality wise, again, it's how one person read the land use code and how another person read the land use code as to your determinations, and I get it. But we gotta figure out what to do with this county. If we can, I don't know if we can. I don't know
So
if
this
that's-
is the thing,
We're kinda in a bad
what I
spot.
think it is, I mean, this is just my philosophy on local government, is we're just, what we need to do is engage the county. When you say what's good for the county, I think the residents of the county
Well, that's what
need
I,
to weigh, well, they need to weigh in.
Right.
That's the thing. And I keep hearing this a lot about how there's no opportunity. And I'm not saying that's not true for people to participate, but I feel like inviting them in specifically to do a job with us that creates something that everybody, I mean, I think everybody needs to learn how to compromise anyway, you know, but I think having robust conversations with different stakeholders, we might actually just find our way to a place where the county is benefiting because everybody got something out of it, right? And I just feel like there's a transparency thing that people are just clamoring for right now, which kind of leads me to another thing that I just want to kind of toss out there. So I went to a community meeting a couple weeks ago in Mancos, and I won't get into the details, but a lot of that conversation, I would say, revolved around some fearfulness from the community. And I think that the thing with the glamping over there, that definitely kind of lit a spark, and things like this will do that. But I think right now there's just a lot of misunderstanding about what the county government does, what the town of Mancos government does, what the land use code even says. How do people does anybody even know what the comprehensive plans are, and kind of how all that blends together with the land use codes? And so one thing that we could consider, and I've talked to somebody, I didn't get a chance to talk to Don about it, but I did talk to James Dietrich at the county, and he said, yeah, years ago, when folks wanted to have a conversation, there's a lot of concerns around the land use code. At that point, some members or all the members of the Planning and Zoning Commission just did some outreach events and just invited the community, like moved it around the county and said, hey, why don't you come in and ask questions about the land use code? Because like we complain all the time, like, why doesn't anybody know about the land use code? And, you know, and I know, you know, there's a limit to, at least my personal opinion, there's a limit to like the government like going out and like making sure everybody understands things. I mean, people got to show up, but I think it's kind of a two-way street. So it's kind of in relation to this like solar code thing. I'm interested, at least, in providing some opportunities for more community involvement, just based on what I'm hearing about this idea that we're making decisions kind of in this silo. And when people say, you know, it's not working for the county, it's hard for them to really kind of put a finger on it. And I think if people had a chance to kind of talk about it a little bit, and we could break down some of those barriers for public participation kind of through this process, it might be a healthy thing to do.
We could hold like a workshop then.
Well, I mean, I'm thinking like, yeah, workshops, like maybe do, yeah.
Especially for the solar thing.
Well, and I mean, I don't want to put this on Don either, because like he's the one that like actually takes it from the community, but you know, and I think there's also some jeopardy for us getting out there and talking about things that may have legal consequences for the county. But I also think there's a general way we can like present, like, this is your land use code. The community created this, and there is a distinct possibility that it does need to have some revisions, or maybe it needs to be clearer for people. I don't know, make it more user-friendly. I don't know. Some of these things are maybe impossible. But I really am interested, if you guys are, in moving a couple of things around the county, like do one here, that's fine, or we can do one, you know, anywhere like out in Dove Creek or something like that, and move it to Dolores, move it over to Mancos, and just give community members that want the opportunity to weigh in. And I mean, I think that might be healthy.
If nothing else, you know, do it on the pretext of this solar, and then, you know, do it off as something else. But the solar, I mean, if we hold a meeting, we gotta put it public, right?
Right.
Of course, yeah.
So, yeah. So
I
we
mean, I
gotta put
kinda
it.
hate to talk about the solar question without knowing what the revenue aspects of the answer are. Is it of benefit to the county from a revenue?
This is
Right,
gonna
that's
be-
what I
So-
said, we need a
This
stakeholder.
is gonna be more beneficial for the people of the county so that they know what's going on. Because revenue at this point isn't gonna matter. It's the safety of the county. Because now you've got, you know, this 1,000-acre solar farm over here. Well, solar lasts 10, 15 years.
Oh, well, 20, 25, yeah.
Okay.
Leases are for 35.
Yeah, 25, yeah.
Yeah, but, I mean,
Is there a safety
theoretically,
issue
if you
with
talk
that?
to the people in the industry, in this area, they'll tell you how long it'll last. Not what the experts say, but I'm just saying, in 30 years, if it lasts 30 years, the solar company now has no use for those solar panels. Who pays for the
Oh, yeah,
approval
we
of the
gotta
solar
recommend
panels?
it. It's got-
No,
it's
I
gotta
know,
have
but I'm
recognition.
just,
So that-
Here's the thing, I'm not advocating we get out there before we know what we want to
Yeah.
talk about. Like,
okay,
let's do our research,
no, exactly.
but I mean, at some point, we should probably try to provide at least a little bit of public input into it. And just, you know, try to be a little more holistic in our approach to this particular,
I'd like to see, you know, I'm okay with that.
because there's pros and cons.
Yeah. yeah.
So-
And then-
But the other stuff was more just general, not like issue specific, just like, hey,
Right.
let's just, hey, don't be scared, it's a land use code, come on in and let's talk about it and ask questions. I did a agri-tourism workshop like last month. And what it was is I just brought some resources in to help people talk about their business planning and things like that. And the biggest question I got was like, we don't understand what we can and can't do.
Mhm.
Now, I always explain to people, you know, like, there's a danger of being too specific about uses and things like that. That'll kind of hamstring certain things too. But it was just clear, like, they just didn't even know where to start, you know? And folks, and, you know, we can keep, like, all the threshold standards. I think that's a perfect way to sort of evaluate ideas. And I think the people I talked to at that shop were like, oh, yeah, I totally understand that now. But it had to have a conversation for people to get how it works instead of just saying, well, the county won't let me do it. And like, well, how do you know that? You haven't.
The other thing you got to take into account is what the public's definition is of agritourism.
Well, this is the
Because
thing.
that could cover 300 different things.
So I was on so I did a statewide call with a bunch of folks that had successful agritourism businesses, and they said the number one hurdle was getting the county to understand what it was they were asking for, because it didn't fit super great. But they didn't really have any solid suggestions on like we could have like the town of Mancos, for instance. We've got these huge charts full of these approved uses by right in each zone we have, and I'm not saying the county needs to adopt that. But I think if, you know, we were able to have some conversations with some people and just say, well, not everything's going to be contemplated in the language, but it's still possible, and here's how this works, I think it would just go a long way to helping people feel more empowered. So,
Well, if we do going back to the solar, if
Yeah.
we do have solar people, you know, have just a workshop on that, then yes, you bring in Empire Electric, you bring somebody in from Tri-State, you bring some solar people in
Yeah,
also, so.
Do we
now-
know any
now you tell
nuclear
me,
people?
okay, this is how it's built, this is how it goes out, even
You're
though,
gonna need the people that
yeah,
do the product.
yeah.
You know, I mean, Empire and all those guys, they're users. So you need the actual people that.
do you think we could get them
I
to
mean,
do that?
Yeah, I have solar on mine.
You could ask, I guess.
So, it goes feeding directly into the grid, into Empire Electric's grid. Because I don't want batteries in my house, because batteries are hazardous material, you better dispose that. So, yeah, feed it right into the grid. Another one?
These are your obligations under that notice that I just served you on like that.
Okay, I'll read it, I promise.
You have a motion?
No, we're still talking about this.
Thank you.
I'm like, you read it.
You have a motion.
Do I have a motion?
Yeah, to
Okay.
put together
Okay.
a workshop.
Yeah, I'll make a motion that the Planning and Zoning Commission for Montezuma County to hold a solar scale or utility scale solar workshop with the community at a date to be determined.
Okay.
I'll second that.
Everybody okay with that?
No, I'm fine with it.
Vote, aye.
Okay.
Okay. You do it, you gotta set it up.
I'd like to talk about the other stuff too, but maybe when Haley's here.
Yeah.
I'd like to have a full board on that.
Yeah, let's do this because we're tasked with this. up front.
Exactly.
Yeah.
Well,
send us-
let me start with the proposed code and language
Okay.
that the commissioners want
Okay,
and are reviewed, and that would be out of Mesa County.
yeah, send us that, yeah.
And I will also send you the NREL report, which came from CCI. I think, I don't try and track all these things. Jason sent me some stuff yesterday or this morning. And I will include that. So basically, our land use code does cover utility sales scale solar.
But we're talking
It includes
utilities.
decommissioning, it includes bonds and sureties.
Better.
So in processing our application now, we're not like going out there blind. And we don't want to get so prescriptive that we don't even know, what language we're trying to come up with, because we're just trying to fit 17 things in a box. Our land use code now, because it's survived for 25 years, is because it's not so prescriptive. If it's that prescriptive, well, they could come to my office, we're gonna check off 8 boxes, and if you don't get it approved. If they do, then we don't need you guys.
Can you distill it down for, I guess, me? Like, what is the biggest concern from the county commissioners? Like, what's the biggest gap that they see in what's there
The
already?
biggest hiccup they had, the biggest concern was decommissioning.
That's what I thought.
And
Well, that goes,
and how you would,
bond.
to make sure in 30 years that the funds are there to take care of it if the companies walk off. The other thing is, that came out of, I don't remember, I've read so many things, is that oversight, because all of these solar companies, or a lot of them, establish them, get them running, and they sell them.
Yeah, that's what they do.
So one option is to have the county commissioners have to approve for the buyer of who the buyer is and what those conditions are.
Is there any way we can put onus on the recipient, i.e., in this case, the major electric transmission generation people, Tri-State, WAPA? Can we put anything on them for accepting that power?
No.
That's it, that's gonna be a legal.
You're way over your head there.
No, that's gonna be a legal question for Stephen, because they are the ones accepting that power
So-
from that particular generation.
Yeah, but those
System.
contracts are way outside of planning and zoning or the county. We
I'm
can't control federal and state power and co-ops and energy companies.
Yeah, but they're not. I mean,
Tri-State
is a quasi, for-profit, utility.
Right, but-
WAPA's the same way.
What power do you think we have over them?
No, I don't say we have power, but.
So we couldn't make them do anything or admit to anything or agree to anything or even talk to us.
Everything's under
I disagree with that. I disagree with that.
It's just like if Empire
Yeah.
wants to go run new power lines, we don't approve that. That's a public utility, and they get to go run them where they want to run them. And
Not
along
in the
along
street,
all
they
the
can't. Not in
roads.
the street, they can. If you hold the franchise to that street, you can control them. Oh, that's what I was gonna talk to you about, don't let me forget. Easement. Quick.
So, are there, I've heard rumors of things that the legislature of Colorado has passed in regard to solar, large-scale solar. Are there any of those regulations that we need to know in terms of what we're gonna be working on?
Yeah, for sure, but I don't know if they're ever gonna be done changing them. They're changing so much stuff now that I don't know how you keep up.
Is there anything in place right now?
Not that I have my hands on.
Is that a DORA?
We'll find out from CCI.
Is that DORA that does that? Regulatory agencies, are they the ones at the state level that deal with utilities?
They should be, and they should at least have the new legislation that's out.
I'll dig in a little bit, and if I find anything that's useful, I'll send it
Okay,
to
good.
Don,
Okay,
he can
send it to
send
him
it
and they
out.
quote us. We should call this, what did you call it? Generated, no. Get the word solar out of here. Get the word solar because.
Renewable.
It's
Renewable.
no,
Right.
it's not renewable. It's alternate energy.
Alternate.
Okay, alternate energy.
Yeah,
Okay,
let's do
but
it
we
that
need,
way.
because it could be solar, it could be wind, and now it could be nuke.
Be geothermal.
Geothermal. So we should encompass everything.
Natural gas, coal, all of it.
But the direction is
Yeah, but if it's.
address
if it's
all of
alternate-
it, or is it, because I feel like the moratorium was just on the utility scale solar. So are we,
It's utility scale
Period.
energy.
Utility
got
scale
it,
energy.
okay, so we gotta do all of
Yeah,
it.
yeah.
Anybody
So
know
it
anybody
can
in the
encompass any of
small
those.
nuclear
So we're-
industry we can invite to the table?
We want to
Or-
be aware of
Figure
something to
that.
do with nuclear, but we're not going to legislate it.
No. No, it's way over.
It's going to have plenty of
Yeah.
It's gonna be
oversight.
regulated, yeah. it's
Now,
gonna
we
be
may
regulated.
want to, I don't know, because of the technology's newer and newer every day, where these things can go, it's not like building 3 Mile Island.
Right.
Who regulates nuclear?
FERC. FERC does. FERC does.
Okay.
FERC's the oversight. Federal Energy Commission.
Does that trickle down to the state?
No, they're the boss.
And so I will send you
Thanks, yeah,
what I've
sorry,
got,
we're going into the weeds.
and you can listen to, was it Monday's workshop?
Mm-hmm, yeah.
This past Mondays? Okay.
We did the workshop, and then we did the public
They did
hearing on
public hearing
Tuesday.
on Tuesday, yeah.
You can.
I was quite
you-
surprised that there was the positive and the negative.
Yeah, there's both sides if you want to listen to the comments, or you can just buzz through and listen to the commissioners, and then you have a better take from their perspective. But the biggest thing they were leery of was to make sure decommissioning, funding, and property owners weren't just left abandoned should they go bankrupt or whatever.
Mm-hmm. Which I think is a great reason to put the moratorium in place to get that stuff figured out. I think it's,
But our current land use code does include decommissioning bonds
Mm-hmm, yeah. That's the way to do it.
as it stands now.
But
That's
it's-
why I'm-
like you said,
The one that's proposed, you gotta go by the land use code now, right?
Correct.
but if that,
Making sure.
if you got a,
And we will
So-
we'll try and get this out to you early because we're over 500 pages right now.
okay.
Because of all the studies that have to be done.
bonds are gonna be tough.
Yeah,
If you've got a project that can last 30 years, you know, the bond that you put up for the construction today is gonna increase. How do you do that?
I think basically you'd run it through a surety. and have it reviewed every 5 years so that you could keep up with inflation and costs, and who knows what happens. I mean, in 15 years, there may be a whole new panel technology that
Yeah.
they rip them all out and put something else
Put
in.
smaller ones in.
My input is, with the decommissioning or fire, flood, hail, whatever, they will never be disposed of in our landfill. Because you would fill up our landfill, and we don't have the time or $4 million to go build another cell because it's full of solar panels.
You dispose
If they
off-
can, if they haul them in, they can haul them out, and they can go
Dispose
to
off
whatever recycling center wants to take them, but
County, yeah.
that's my own
No,
opinion.
that's good, that's good, dispose off county, yeah.
The propellers for your windmills. I mean, if you ever went to one of those dumps, you'd be
Oh,
amazed.
yeah.
I mean, there's miles and miles and miles of trenches, and they're pushing them in just as fast as they can. Everybody's like, oh, they're great. Well, they last 5, 10 years.
That's it.
and they're done.
That's it.
Yep.
Or if you get a natural disaster or something. I've got relatives in Oklahoma that work in that industry. First time I went by there, I about fell over.
Oh, yeah, go to Palm Springs.
So the county can decide what it will and won't take into the landfill. There's nothing, there's no other rule above it that will supersede that decision?
Well, if it's part of our land use code, that decommissioning,
I'm just saying, like, if we come up and say, like, well, you can't, you're gonna have to decommission and remove the stuff, and you can't take it to the Montezuma County landfill.
We'll take it to a recycle center just like.
Yeah,
they
take
do
it
ours.
off county.
more
That's all you
and
gotta do.
more they're built to.
I just
to
wondered
re-
if there was like any kind of like solid waste disposal rules that prohibit the county from saying they
I don't even
won't
know how
take
you
it.
recycle those things, if they do
Yeah.
recycle solar panels.
They're made to be a lot recycled. I don't know the exact technology or specifics, but if you have a fire out there and you destroy 10,000 panels, I don't think they're gonna go recycle them. I think they're gonna pull them off and go dump them somewhere.
Absolutely.
Out of county, out of.
But
county.
that's, I'm just winging that. That's my idea.
Good idea.
Don, because the land use code is a set of regulations for the county, the only regulations that it falls, or that override it are state law and federal law, correct? So as long as the state doesn't say we have to take solar panels.
That's my
We
question.
can put it in the land use code that we're not gonna take
Yeah,
solar
and
panels.
I just wonder if that's coming.
How can the state tell you you're gonna take?
I
When you
mean,
say
they can
take
try to
those
do
things
anything, but
Into the land.
I'm not saying they're doing it
And
now.
allow them, right?
Yeah, they can't tell you that, yeah.
Well, the state gives us unfunded mandates all the time.
Exactly,
But they haven't yet.
exactly. So, that's the only thing I was asking. It's
About
like, is there
10% of the new laws are unfunded mandates.
That's gonna be
Yeah.
the,
And this is how they, anyway.
That's what the state does.
Or now the term is underfunded.
Underfunded
Underfunded,
mandate.
that's right.
Yeah, they changed the language so that it doesn't follow under statute anymore.
Yeah,
They're underfunded mandates.
yeah, I listened to that too before.
Suggestions.
All right, motion to adjourn?
motion to adjourn. I better write it down.